Okay, let's get the committee meeting going. And Megan, if you would call the roll, please.
Senator Carroll, Senator Neal, Senator Nunn,
Here.
Senator Reed,
Here.
Senator Thomas, Senator Wheeler, Representative Blanton,
Here.
Representative Burke, Representative Camuel,
Here.
Representative Lockett,
Here.
Representative Riley, Representative Smith, Representative Williams, Senator Howell, Senator Elkins, Representative Sharp.
Present. All right. How's that better? Thanks. And being at war for that period of time, lost a lot of people 24 years ago today. A lot of citizens, non-combatants, and we lost a lot of soldiers and service members since then. So I would like to take a moment of silence and reflect back on that, if you don't mind. Okay. The next, I'd like to get Mr. Marshall up on desk here, please. Mr. Marshall, if you could, for the record, state your name, position.
Michael Brandon Marshall. I am the SWIC for the Commonwealth of Kentucky with the Kentucky State Police Communications Branch.
Okay. Can you tell for the record, what SWIC is?
It's the Statewide Interoperability Coordinator.
Okay. Thank you. Mr. Marshall, do you so solemnly swear or affirm your testimony here is the truth to the best of your knowledge?
I do, sir.
Okay, thank you. All right, what we'd like to do is get an update on where we're at since your last meeting here and what you project in the next 30, 60, and 90 days.
Absolutely. So I think that we're going to be meeting here routinely moving forward every month and attempting to try to capture what that scope of work of what we've done in the last 30 days as well as what we've got planned moving forward into the next 30 days. So for this meeting, I'm going to try to take us back a little further and capture all that we've accomplished through the process to give us that baseline of where we are today.
As long as you don't repeat too much of what you said last month, we're okay.
I'll do my very best, sir. Very best. So we're building out the statewide emergency responder voice system, or SERVS. This project started with a replacement for the Kentucky State Police's existing radio system and has spawned into a statewide trunk radio system to serve all of public safety across the Commonwealth. We've been generously funded by the legislative body for 4 budget cycles in a row, and we have taken that money and done a lot of good things, and I want to show you what those things are really fast. So we started out building in a west to east manner. We took 14 existing tower sites that the Commonwealth already owns and operates at, and we put new radio equipment there, new DC power plants there to support that radio equipment, and hardened those sites with generators and things that would allow them to operate at a higher, more stable, redundant level. We also acquired property for additional tower sites were constructed on those 4 properties to expand upon the system and give that system more coverage. And that was what we did in phase 1. Now in phase 2, we moved into the central part of Kentucky from west to east, all the way over to that I-75 corridor. And 47 sites there within Phase 2 have had a great deal of work done to them. And you can see them there in green on that screen now. Normally my presentation is in the form of a PowerPoint, and it's a little different today, so it's a little awkward for me, but I'll muddle through if you all are patient with me. The 47 green sites have had a great deal of work done to them, so they again have had probably close to $1 million worth of investment at each one of those sites in new radio equipment and antennas and tower work and those redundant hardening things such as generators and DC plants. And there are 17 new sites that were identified there in Phase 2, 2 of which are being built right now. The other 15 are in some various stage of the property acquisition process. When we were in Phase 2, at that point, we recognized there was a great deal of risks that we hadn't known. So it took a while to capture that, but we learned a few things. What we learned was CEWS, or the Kentucky Emergency Warning System, which is the microwave network owned by the Commonwealth of Kentucky that the state police's radio system resides upon. So CEWS, I want you to think of it as a links of string going from one tower site to the next, but it's not actual string. It's wireless data transmitted in a point-to-point manner that connects all of these sites together. What we recognized is that CEWS was in need of an overhaul itself to support the new radio system. So in the third fiscal year of which third fiscal biennium, we decided that we needed to address those things. So we asked for additional funding to do that and was graciously awarded. And we began working on now, not just building out serves, but also totally redoing CEWS. So the project expanded in scope quite a bit there. And with that, the very first thing that had to occur was the power plants there had to be changed to support the new microwave equipment that was going to go into place of the old. The routing equipment that actually translates the ones and zeros from one end to the other, or as we refer to it as the network, all of that equipment had to be replaced as well. So you have to replace the DC power plants first. That work was done. Then on to the routers. And as you can see here, 130 routers have been replaced to date at each one of these sites. A good investment at those sites. And we've got other routers that are sitting aside waiting for when our new sites are acquired and built that we can install that equipment there and begin that conversion process of CEWS to support serves. Additionally, that microwave equipment had to be upgraded as well. And to date, we've replaced 56 microwave stations at each one of these sites, and there will be 76 more that'll be done in 2026 as a whole. And we've got, of course, microwave equipment that we've already procured waiting for those greenfield sites that we're going to build and add on. And greenfield means a brand new site that was never built there before. So when you hear me use that terminology of greenfield, that's what I'm referring to. I'm referring to a new site to us, brand new. You will see this number change in our next 30-day report. So this process is actively ongoing right now, and we expect the entire microwave upgrade for those sites that we have today to be completely finished within 2026, so that the rest of Kentucky is ready to support the radio system or serves as it's built out. So there's your first little inkling or glance into what you're going to see in your next 30-day report. You're going to see that number shift upward and that work continue to happen, provided that the weather is okay and those people can make it to those sites and install that equipment.
All right, can you be more specific? Give me a high end and a low end to how these numbers are going to change.
I would say high end, you're probably going to see somewhere around one site per day of a working day. So you'll probably see, give or take with the mobilization and the driving, and let's call it 20 sites. I would think that you would assume that number would have been moved to 76 by next month, or we would have a very good reason to explain to you why it hasn't moved 20 sites, sir.
Thank you.
And with that, now we're back to serves, which was the original end goal to begin with. So serves in itself now would be building out into phase 3A. There is work that is going to be starting, hopefully this next month, at those green dots that you see there. So those are existing sites that we are getting ready to begin installing new radio equipment at. Now that process will take much longer to install that radio system, rack and console and antennas. Some of those sites are going to have to require some physical structural hardening to support the new hardware being mounted onto those towers. So it's much more difficult to give you a high estimate. If I was going to give you an estimate there, I would think that within the next 30 days, you would see probably 1 to 2 of those sites be completed on the radio system side, and probably more along the lines of about 5 sites each month after that. And I'd much rather underpromise and overdeliver on those numbers. So I'm probably being a little bit conservative.
I'm just looking for a ballpark figure.
Understand.
What to expect.
Understand. Something we can be held accountable to, as we should. And this is what we're asking for later in that next budget cycle. So no work will be reported on that. It's just to keep it on your radar of this will finish out the rest of the state. The request that we've got that will hopefully be in the capital request is to complete serves across the state. With what we have online today, this is what that radio system coverage looks like. And Senator Wheeler, I see you taking pictures. I'm sure we can get you a copy of that too, if you'd like to see it. And I would encourage us to dive deeper into this during those reports moving forward. I think what I'd like to be able to show you all next month is zoomed in views of each one of what we consider post areas. You can see we've got the state broken into the KSP post territories. And I'd like to show you, as part of our monthly report, zoomed in looks at what that radio coverage is like, because you'll see a couple of things that way. You'll see the great coverage that your funding has built out for public safety, as well as you'll see the gaps in that radio system coverage around these yellow dots of the sites that I haven't built yet. And you'll see why we desperately need to complete those sites to finish that layer of coverage. I think that it's important to note in this instance that at every one of these green dots where we've got work that has been fully completed and the radio system serves is operational, there is a use case there. We can begin to provide service to local agencies around those areas. So as of right now, here in Post 1 and here in Post 2, the Kentucky State Police is fully up and online. And I can do that in those areas because there's no orange dots there, right? I've built 4 tower sites there. We've acquired property and we've already built them. And we're not trying to acquire those moving forward. So I have full coverage across those areas, best that I could expect, that is public safety grade that the state police can use. We are beginning to add local agencies to that system. So I expect in our next 30-day report that you are probably going to hear at least of one local agency that's been added. So we're in talks with them. We've got an MOU that's been produced. They've tested the system. I've gotten great feedback from them, other than I think it's the same general consensus about the project overall is this is great and we want it right now. Why can't we be on it right now? So hopefully in the next 30 days you'll hear that they are on it. I'd like to get that MOU completed and get them on it. But I'd like to dive in deeper on each one of these moving forward into our reports. I think that would be incredibly beneficial for you all. So that routing system will change. That radio system installation over here in these areas will change. If you all can see my mouse moving, I hope you can. What we consider to be the post 8, the post 14, the post 11 areas. You'll see that green and purple move out there once we start turning some of those blue sites to green. So those are existing sites.
Okay, so in the next 30 days, we can expect a maximum of 22 up and running, 22 sites.
So there's different levels of up and running. So the microwave has to be put into place before the radio system can be put into place there. And as you can see, there's a great deal of sites that are on right now today. And the site has to be an actual real site, right? All of these orange dots, those are not real tower sites today. There's not an actual tower there that I could begin working on if I wanted to. And I do want to, but I can't do that until that tower is acquired and built.
All right, so you said 1 to 2 in the next 30 days in phase 3A, and then you told us that there was going to be a maximum of 20. What are you referring to there then?
So that is the microwave upgrade. So
That's the microwave upgrade.
and
okay.
that's part of that scope of work that we didn't realize or recognize moving forward. So that was Q's at that time wasn't managed by our group. Now they are. Now they're a portion of the Kentucky State Police. We've consolidated with them. But we consolidated, and now we're addressing those concerns. And that was in the third biennium of our budget request. When we requested all that additional funding, that's what that was for. And you're seeing the fruits of that labor right now. So that microwave has been replaced at all of those green dots and is moving into those blue dots. And we hope to have that fully completed in 2026. All of those blue dots to green at all of those existing sites. You should see approximately 20 or so that will pop up from blue to green next month. I would hope, sir.
Okay, thank you. Now, because of the duration of this project, it's been going on for so long, we plan on having you in here every month to get an update of where we're at and where we're going.
We will be here, sir.
Okay, and I just want to make sure that you realize that it's not you personally, it's this whole project, and I know it's echelons above you, and we want to know what's going on, and if we have to call somebody else in, we plan on doing that. All right, I believe we have a question here from Senator Wheeler.
Thank you, Mr. Chairman, and I guess as you correctly noticed when I was looking at the map, it appears there's no coverage at all within my Senate district, I guess, according to the map or Senator Maiden's, and I think Representative Sharp's looked a little bit bald too up through there. I just happened to be driving down the road in Pikeville yesterday and probably should, and I was not successful, but I happened to see a truck, I think it was from maybe one of the power companies, that had obviously what looked like a Starlink receiver on top of it that was driving down the road, and I know someone that works for AEP in West Virginia that is a crew chief and has Starlink on his truck and can get service anywhere. I think it actually rotates around so they can kind of get the signal and everything like that. I mean, to what extent? And I know you've already gotten pretty heavy into the current system as it is, but for maybe more mountainous and remote areas, which I think are much more difficult to get coverage in, to what extent could we possibly utilize some of these advanced technologies that are being used in the private sector to accomplish what we're trying to do here rather than, maybe building all these towers? I mean, could we not just buy the maybe $175 kit and mount it on top of our cruisers or something like that, and would that be a cheaper expense than what we're doing right here?
So I hope you're not going to regret asking me this question, because I'm really fascinated by low orbit satellite technology at which that Starlink is based upon. It's absolutely going to be a game changer in the communications field. It already has proven to be. So satellite technology has been around a long time, and we've exploited that. What's different about this newer technology is that low orbit satellite can transmit and receive so much faster. So you get those increased speeds that you could not get prior to with other traditional older satellite technologies. And it's because it's physically closer to the Earth, or they are physically closer to the Earth, because they actually orbit. So you have to have an entire grid of those. So The network itself isn't completely built to cover fully in all of Kentucky yet, and I know because part of one of our roles is we prepare a great deal for disaster response and emergency communications to support that type of response. And we actually have some low orbit satellite technology. I'm not a bigger fan of one brand that you mentioned as opposed to another, but it all is fantastic technology. Here's the thing to note about satellite technology, and it's always been that real hurdle to using that to provide service to law enforcement. I'm not saying it can't, but here's the challenge. The challenge is line of sight. So in order to communicate with those satellites, you have to actually see the sky. So for instance, satellite phones have been around for a long time, and we received a telephone call during a blackout period from corrections who had some satellite phones, and they had gone to someone else and gotten a call out and said, we can't get our satellite phones to work. Well, they couldn't get their satellite phones to work because they were indoors. They were inside the prison. They were in the bunker, and that's never going to work, right? So if law enforcement, if public safety only served outdoors, service outdoors, then absolutely that's a method that could work. But that's not the case. We do a great deal indoors, right? We respond. Firefighters go inside buildings, law enforcement goes inside buildings, EMS picks up people and drops off people in buildings. So when is technology going to catch up and bridge that last gap of providing that level of service indoors as well? So there's been some movement this past week. I think it was a $17 billion acquisition, if you keep up with tech comms stuff, and I do. But there was a $17 billion acquisition of RF radio spectrum, same stuff that I'm using to provide this level of service, and that was purchased by the private sector. And I think, and I don't know, but I think their intention there is they're going to take their low orbit satellite technology and then link it together using that, link tower sites together using that low orbit satellite technology, very similar to what I do fully terrestrial with my microwave dishes shooting back and forth, right? And then they're going to give that last mile of service to the customer on a device like this via 700 megahertz spectrum, radio spectrum, which is exactly what I do, right? So even that market, you have to find a way to bridge that gap, that last mile of service. And it looks to me like the private sector is now turning and going back to the same direction that I'm already in, and looking at using that radio spectrum. Did I fully answer your question before I go on to Senator
think that
Thomas?
was a very, you obviously know some of the technology here, and I thought that was a very concise and excellent answer, and I'm satisfied with it. So yeah, so what you're essentially saying, if I understand you, is this could be a tool in the toolbox.
Absolutely.
For sure, but I guess one other thing, like I said, I know with my friend Jeff's thing, I mean, I think he can rotate it to try to get that line of sight. Now,
Yes, sir.
Obviously getting inside the house, and again, I don't know how that works. He's probably typically working outside, like you said, but I mean, I didn't know, as far as if it's on their cell phone or something, generally I would think there's at least some radius in reference to the vehicle that you're going to have, for lack of a better term, Wi-Fi coverage that might penetrate the walls as well, would you not?
So there's another way to, again, to try to tackle that last mile, right? And
Yeah.
you're right on par with exactly what I'm saying. Wi-Fi is somewhere around the 4 gigahertz frequency, which makes it less likely and less capable to penetrate buildings than 700 megahertz frequency, which penetrates through buildings and steel, whatnot, in a better way because of the physics. That lower frequency penetrates better. You can get to a point where that you go too low the other way, and it doesn't. But 700 megahertz, 400 megahertz, those bands are really the sweet spots.
Do they make routers or something like that you could use in conjunction with these low orbit satellite technologies to get to 700?
So it wouldn't be a router.
Oh,
It
well, I
would be,
mean,
it would
I
be-
don't know the lingo. You're
It would
you're
be
educated.
radio, right?
Radio.
It would be radio. So that spectrum is dedicated to radio
Okay.
and cellular devices as well, right?
Okay.
So you can use that spectrum for 700 or for cellular devices as well. But
All right.
absolutely, and we're getting there, and that's kind of what we're doing.
Okay. Thank you very much, Mr. Chairman. Thank you.
No, thank
Okay,
you.
Senator Thomas, please.
Thank you, Mr. Chair. And I'm going to be more direct than my colleague, Senator Wheeler, because, I look at that map and I say that map is highly unfavorable to Eastern Kentucky. I mean, frankly speaking, and I don't want to be mean here, but frankly speaking, that is an awful looking map. It's just an awful looking map. I mean, Western Kentucky has coverage. Southern Kentucky has coverage. Your metropolitan areas, Louisville, Northern Kentucky, and Lexington have coverage. But from Whitley County and McCreary County, all the way up to Lewis County, they have no coverage. And that's just unacceptable. I mean, I'm just telling you, that's unacceptable. So my question to you is just very simple. When is that going to be fixed? We're talking about the statewide emergency response system here. And you've got Whitley County, McCreary County, on up to Lewis County with no coverage. So when is that going to be fixed?
So we're working towards that, and I would love to be able to give you that date of when will I have this fully on in Eastern Kentucky. I can tell you that by the end of 2026, I would expect to see this area all around what I consider post 14, this area which I consider post 8, and this area, which I believe is Whitley County, is down here, which is post 11. Those areas will be live and have coverage very similar to the counties east of or west of them. These will not. So these 3 post areas will not. We haven't been funded to build those out yet. We will be asking for funding to build those out. We had to start somewhere, Senator Thomas. And we chose to start in Western Kentucky, and it wasn't because we favored Western Kentucky, and it wasn't because we even felt like Western Kentucky had a larger need. It was purely a technical decision, and the technical decision was when you start building out radio systems, it's very impacted by the terrain and the geography. So it's much easier to provide radio coverage over flat ground than it is ground that is full of hills and mountains and changing. And you see that in your cellular service now. You can be in areas where the ground is flat and fairly level, or here in the Golden Triangle where it's completely saturated. But in Eastern Kentucky, it's difficult. And it's not that we're not going to build out there. We are building out there. Our goal is to get out there and provide that level of coverage. It was simply about, let's take the easier part first and learn what we need to learn.
All right, we're rehashing old information. Senator
Okay.
Thomas, do you have a follow-up?
I have no problem.
Okay. I do have a question, though. The initial part of this money that was given to you guys to build this out, didn't it include the southeast right there that you're going to be requesting money for? Wasn't that considered?
So this portion of the southeast was talked about and considered in one time, but those monies had to be reallocated for construction costs.
Okay.
So yes, sir, it has been considered.
But it was initially in part of the initial budgeting, but you reallocated those somewhere else.
So our request has changed each year according to, or in each budget cycle, and we've been funded 4 times, and our request has changed and the scope of work changed with it according to what did we actually get done and what can we actually accomplish, and where do we need to make an investment right now in order to try to control the overall expense of the project.
Okay. Representative Smith.
Thank you, Mr. Chairman. I'll be brief. In these contracts that are given for the construction, they come through a tier 1. You have a main contractor that gets the contract, an engineering group, and then it goes to subs off of them. Is that your understanding how the contracts are given, or you don't deal with them at all, or?
So we are spectators of that process
Okay.
and somewhat active in the designing of the scope of work.
Okay,
So we help establish what that scope of work is. We look at work with the Division of Engineering Construction Administration and determine whether or not we feel like that scope of work has been met adequately. But those contracts are all done by the finance cabinet there in DECA, as they say, or Division of Engineering Construction Authority.
okay,
They manage that construction and they manage those contracts. We are users thereof.
okay. I think some of the delays I've been getting a little more in depth in this because I have a local contractor who's done some work for this project. Mountain, I believe I talked to you about them and you're aware of them. That's done some work and done the buildings, the sites. And I think it became more a lot harder to find not the properties, but to find in the terrain how to get these sites to the specific spots that's needed to make a regional coverage. And so I think that's been part of the delay. But what I'm finding out too is that maybe it was a learning curve from the beginning on how to get this established in the whole state, on learning through trial and error, finding out what you was up against on trying to get these sites. That's what I've heard in the last few testimonies, was purchasing a property, finding the delays, and finding these, I would call them pinpoints, where you have to have the tower out to reach these sites. But you answered my question. You're not involved at all in the contractual part of it then. You're only involved in oversight.
Yes, sir. So we are involved in that level. We establish that scope of work. We review that scope of work, but we're actually not even, we don't even directly interact with the subcontractor. So DECA is very clear about that.
Just one quick follow-up, Mr. Chairman.
Sure.
So you said something that caught my attention there. So you sit down and lay out a time frame on each one of these buildings that you're involved in the site prep, on what the site prep's going to take, the building to get in there, the cutting of the roads, the terrain, the time frame that you're going to allow these contractors. So you're involved in that part of it.
So we don't establish the time frame of which the work is completed. We merely establish what the scope of work is.
Okay.
What needs to be done. I can tell you what needs to be done from a standpoint of I know I need a road, and I know I need a piece of ground leveled off and a fence and a compound and a tower. I know those things. I don't know from a construction standpoint because I don't have that background. I can talk with Senator Wheeler about low orbit satellite all day long, and we're in my wheelhouse there. But when we talk about construction, I know a lot more about tower construction now than I ever have before. But it's a byproduct of this process. I'm not in the construction business. I don't have a background there.
Thank you, Mr. Chairman.
Okay. I do not see any other questions for Mr. Marshall. Mr. Marshall, I'll be looking forward to seeing you next month with an update on where we're at and where we're going.
I look forward to you all being provided an update too, sir. And we appreciate your time and we appreciate this committee's support.
Okay, thank you. All right, next on our agenda, stand by one. I would like to have the Administrative Office of the Courts come up, Daniel Stuyvesant and Zach Ramsey, please. If you could hit the button there in front of you, there you go.
There you go. We have our general counsel, Margaret Ivy, who's with us also.
That's fine.
Be able to answer
That's fine.
questions.
If you could introduce yourself and your positions.
Sure. I'm Zach Ramsey. I'm the director of the Administrative Office of the Courts.
I'm Daniel Sturdivant, the data officer with the Administrative Office of the Courts.
Margaret Ivy, General Counsel for the Administrative Office of the Courts.
Okay, I appreciate you all being here, and today we're here to talk about the shock probation generally as it speaks to what's going on in the Commonwealth, and we'd like to get a little bit of information on that, if you would, please.
Sure, and I think as the committee knows, we submitted a report that Daniel and his data officer team ran over the last week that pulls some of that information out of our CourtNet system, which is our online system that tracks from our official paper record in each courthouse and gives us that information. It's my understanding, I've been with the AOC about 10 months, that we have not run a report like this before. It's kind of our first foray into analyzing it. So we know, we've kind of pulled the best data that we have, made some assumptions and some disclaimers in the report that you can see, but we can certainly go back and maybe drill down in some other areas as we go forward. So that's some of our limitations. And just and Margaret can certainly keep me honest, just to chime in a little bit about what shock probation is relative to what we do at AOC. This is a post-adjudication event where somebody has already been convicted, they've already been sentenced, they're in the custody of corrections, and at some period of time under the statute that authorizes the shock probation process, a motion is made by the defendant's counsel, back to that judge who imposed the sentence within certain timeframes that are laid out in statute. And then that judge has a discretionary decision based on it's our understanding, the facts and circumstances of each case within the confines of the statute, eligible offenses, is it violent, is it a sex crime, to either a grant or deny that motion for shock probation. And then from there, that's some of the data that we've collected. It then, if it's granted, it goes to probation and parole. And of course, they're overseeing that program from there. So the curtain kind of comes down, for the courts and what we collect at that point as far as the ultimate outcome. But we have within this report made our best attempt so far to go back through the charge disposition, which is a bit of a misnomer because we track based on charges in a lot of what's in CourtNet, but what it really is a motion, as I mentioned, that's been made by the defendant after the defendant has been sentenced. So we've done our best to kind of go through and develop a count of those total cases and charges over the last 2023, 2024, 2025 fiscal years to show you how many motions were made, essentially, how many were denied, how many were granted, and then breaking those down between felony and misdemeanor with a little more flavor in there. So that's...
If we could,
Sure.
For the committee and for everyone watching from KET, could you tell us exactly what shock probation is and in what cases would it be used? I think we need to set that as a foundation.
Okay, I'm going to let my general counsel do that because it's not our official program, but we know what we know from the statutes.
Yeah, so KRS 439-265 sets forth the shock probation and felony convictions. And again, that statute simply gives a time frame in which after a defendant has been sentenced, they can motion and ask for a change in their sentence, right? So a defendant has been sentenced on a felony conviction between 30 days and 180 days, they can come back in court. Generally, a court loses jurisdiction to modify a sentence 10 days after a conviction, but this statute gives them the authority to reconsider a probated sentence for somebody that's been sentenced to a term of incarceration. So that's what the statute does. The only limitations that are in there are those offenses that are not going to be eligible, and then as well as some offenses that may require additional reports to be considered by the court before granting. But there's nothing in terms of kind of criteria that a court might use. So it really is kind of a both the felony statute and the misdemeanor statute kind of a you're either convicted of these types of offenses and are therefore ineligible, or you are eligible and it kind of becomes a matter of discretion. Defendants file these either themselves pro se or through their attorney, but it's completely discretionary. So whether a defendant chooses to seek shock probation is just a matter of their personal preference, in their discretion. And then again, the granting of them is a circumstantial kind of question that comes before the court. The other statute that relates to misdemeanors is KRS 439.267. And again, very similar to the felony statute, except for there are no restrictions there except for additional reports that they want the court to consider.
I think it's my understanding, and Margaret can correct me, that the parameters that are put around that probation, it's just another form of probation. Those
Yeah.
are established by the judge. I think as she indicated, they're not laid out in statute or any other rule. Those are parameters that the judges, I believe, within their discretion are imposing as far as certain restrictions that are placed on the defendant in order for them to or mandates that in order for them to successfully complete that probationary period around the parameters that are established. So we would have to go into essentially every record, official court record, and kind of look at, what all those parameters that may have been laid out by the judge or picked up based on the motion that was made by the parties to the case.
Yeah, that's correct. So in both of the statutes, they reference back to the KRS 532.045, which sets forth the general terms of supervision on probation. And so, it basically converts that, what was a in custody incarceration sentence, to a probated sentence, and it becomes basically, in the court's mind, you have the same options available as you would any other probated sentence. We can't speak to if it looks any different on the correction side of the supervision, but in terms of what the court can do and the options available to the court in terms of oversight or program or recommendations, it would look the same for a judge as any other probated sentence.
And one other thing that came in, I think, is a question that was shared with us. I think it's important that we know that 2024 House Bill 5 made some changes to KRS 439-3401 for the purpose of this report, and we could probably dig in a little deeper and employ some other logic. We made the assumption in the time that we had that the current version of that statute, and the new definitions and restrictions in place that are today, we went backwards with that and acted as if those applied for the last 3 years. So I think there was a follow-up question that we received, that there was a number on here that were in the totals. I think it was 221 that were in the violent category, but would go back to the period prior to the enactment of House Bill 5. So we could probably dig in and explain that a little bit more. But what we feel that we're seeing in the data for both 2023, 2024, and 2025 fiscal years is these particular cases, and these charges, and if you track them, they've been going down a little bit from 23 to 2025, would predate new criminal cases subsequent to House Bill 5 from 2024. Because again, as Margaret pointed out, in these criminal cases, this is something that's happened at the very end and after our court case is closed, and the motion is made after someone is incarcerated. So charges that may have been filed in the second half of 2024 and 2025 haven't more than likely haven't worked their way to this stage in the process yet. So we see this overall decline. I think Daniel has shared with me, we still have a decline in the total number of felonies we're seeing statewide in all courts since the pandemic. So it could be reflective of other things, but we would probably need another year at least, to look at this again at the end of fiscal year 2026 to see more of the impact of newer cases that have been filed under the current version of 439-3401 from House Bill 5.
Okay, Senator Wheeler, you have a question?
Thank you, Mr. Chairman. Do you have a couple brief questions, if you permit, Mr. Chairman?
Sure, go ahead.
Do you have any statistics or any type of data that indicates which judges are more likely to grant shock probation and for what offenses?
I'm not aware of anything. I'm not aware that our case system could track along those lines the way it's set up. We've certainly not been asked to do that before, so I can't speak to what's happened in the past.
On the charge screen data element that we used for this report, I do not remember whether the judge is indicated there or not. They may be. It's something we would have to verify.
Yeah, because we were focused on just for this report and what we were trying to provide something meaningful to have this discussion. We were focused on just the total cases and charges and the codes that are associated with it. We may be able to, but I'm not sure.
Okay, and I guess to follow up on that, do you have any information on the recidivism rates of folks that are cut loose early on shock probation, maybe specifically how quick are some of them to offend, and whether or not anybody has been severely hurt or perhaps even killed that has received shock probation from a sentence.
I know, and I'll let Daniel speak to this. We do, I think we noticed in the data there were some of these cases had probation violations, but we haven't figured out the link yet. But a lot of that information, first and foremost, would reside with corrections as the source agency who's overseeing these individuals. If they come back through the court system, then we're certainly going to capture that data. If they later either violate the probation or commit some crime in the future, even after they've satisfied their probation, we would have to go look at that, or maybe expand our period of time, beyond just the 3 years. But we've not looked specific to shock probation.
Well, do you not think that would be important as the administrative agency in charge of our courts to know if perhaps we had for lack of a better term, a rogue judge that was using this or abusing this and putting dangerous people back out on the streets that might commit other crimes?
Well, absolutely. I mean, we certainly can look at the data. I mean, again, we've not been asked to do this, or it's not come up before. So it's not that we don't recognize the importance of it, but it's just not anything we've had occasion to put together before. But we may be able to break this down at a judge level. But a lot of the information that's in and this is where we are from a technology standpoint, a lot of the information that we're looking at online is our CourtNet system. It's not the official court record. As we sit here today, the official court record is still a paper-based record. It's in every courthouse in every state, and that's the official record. So the only way to really know all the circumstances, if anybody were to look at that, would be to go pull that full paper record, case by case. Our data is always going to, at least today, is going to be a little more limited because there's manual entry, and then it moves through to the CourtNet system. So when we say things are limited, we always caveat any data. We're providing data out of our system every day to all sorts of groups. There's always those caveats and disclaimers that if you want to know the source, you still have to look at the official court record. But we're capable of doing those things. We just not had occasion, to do so.
Thank you, Mr. Chairman.
Okay, thank you, Senator. Senator Thomas.
Thank you, Chairman Sharp. I don't practice criminal law. Back in my younger days, when I was new out of law school, I did do some criminal work. I will say that I've seen shock probation work. But you're never going to hear about the thousands of cases where it does work. You're only going to hear about that one where it doesn't. But I do think shock probation is a useful tool, and I've seen it used advantageously to my clients where there was no recidivism. That they spent that 90 days to 120 days in prison, got out, and never returned. So I do think shock probation is a good tool. Senator Wheeler's questions are good questions, and they need to be addressed. But I am very supportive of shock probation and would like to see it to continue to exist here in the state.
Yes, sir, and thank you. One other important thing I want to note, the role of the Administrative Office of the Courts, and there are other agencies that are scoped by law, by statute to do this, to oversee the conduct of judges and all sorts of other groups, but it's not the role of the Administrative Office of the Courts to investigate or offer any oversight or regulatory authority over judges. We're the administrative function. We're largely, we're their payroll, we're fiscal agent. We set a lot of, and we run certain programs by law. It's not that we have the data, so we can support those groups that would look at what judges are doing, or any group that we're doing if we have that data with that appropriate authority. But we, the Administrative Office of the Courts, don't have any authority under any law to investigate or do any sort of oversight of judges in that capacity. In our specific role as the AOC, there are other groups that would do that, and we support anything that may happen appropriately. But I just want to make sure it's clear, because we do get a lot of questions about when there are issues with judges that come to us, and we always have to remind everybody that we don't have the authority to do that.
Okay, thank you. Representative Blanton.
Thank you, Mr. Chairman. I have a couple questions, if I may.
Sure.
Thank you all for being here. First of all, I want to go to page, it says page 3, I guess, where you have, case has shock probation granted / enhanced, and then no shock probation granted, enhanced. Are we there?
Yes, sir.
Okay, so I'm seeing one felony A, violent charge, that's under the category that shock probation was granted in that case? Am I reading that correctly?
That's my understanding, yes. Is that correct, Andy?
I believe so, yes.
Yes.
I'm just curious how that a Class A felony could qualify if it's a violent charge for shock probation, but I guess the judge maybe thought otherwise. That's a little bit concerning. Do we have any data on people who receive shock probation, the recidivism rate for those individuals? Do we know that?
I'm not aware of any,
We've not previously run that, but I think we probably could.
specific to recidivism, those who go
Yes.
back into the system. Yeah, we would have to take a look. We did do a little bit of look. We were trying to get this information together in the time that we had. We have to find the connection between subsequent charges back into this case. You want to make sure you got the right person, that it was within the context of what the parameters were, the shock probation. I mean, we would have to look at that. We may have that information. And we assume that probation and parole may have data around that, since they are actually executing on that, overseeing those individuals who've been ordered by the judge. I mean, once that's all goes to them once a judge renders that order. So, and we've had some conversations with them and, to kind of renew some of our data sharing discussions. It may be a matter of us getting together with corrections and seeing if we can sync up our data, so we've got a more holistic look at everything that's happened with that individual. If it's been so much period of time down the line after the judge has ordered, so we make sure we haven't missed anything.
Very good. One more very quick question.
Sure, go ahead.
Along those lines, could someone qualify or be granted shock probation if they have already been paroled, probated, shock probated, and they have committed another crime? Would they be eligible then for shock probation once again, or would, because of that violation, would that prevent them from being eligible? Does that make sense?
I think so. If I can, you're saying somebody was maybe granted shock probation in one case, and then they maybe at some point pick up a new charge and they file and they ask for shock probation again. There's nothing in the statute currently that would prevent that. It is based upon the limitations that are currently in statute are based upon what you were convicted of and serving a sentence for. So, I mean, that would be something different. But again, one of the kind of things we talk about is that, these are by statute. There's no real guidance on it. It's very factual, kind of whatever the request is, whatever the defendant has said is the basis why they believe that they are a good candidate for it, and what the judge kind of is seeing. And so,
Thank you, Mr. Chairman.
Representative Lockett.
Thank you, Mr. Chairman. I had a question about the data, and I'm on page 1 of your report. Just the totals there that are listed for the charges there in the Can you just tell me, just kind of over from a 10,000 foot level, on the far right you got the grand total, the charges, and then the cases. So 2023 there were 5,869 cases, 24 4952, and then 25 4641. That's a gradual decrease from 23 to 24. It's a pretty significant decrease, and then 24 to 25, somewhat gradual. What do you attribute that decrease to? So is it a decrease in charges? Is it a decrease in convictions? How are we going down and down significantly from in just 3 years?
And I'll
I don't think we know.
One of the challenges we
And
have
that's
is
fair.
that we're just the AOC. I mean
Yeah.
that in a minimal way, but we're not peering into those cases. We don't stand in the shoes of judges. There's a lot of information we don't have, and in our role within the courts. We have to be careful about, I can speculate just based on that I can see and I understand certain things, but we've never had any official role to trend or to track this or offer up anything. So I can't, it could be that, as I mentioned before, that the number of cases and the number of felonies that are charged has been declining. It hasn't reached pre-COVID levels. I think it peaked in 2029, and in 2025, it's still less than it was then.
That's correct.
And so it could be a reflection of, because when I looked at this page one, I ran the percentages between granted and denied over those 3 years, and it went from 32.7 down to 30.1, but it's all been within a percentage point of the numbers that have been denied and the numbers have been granted within the total, even though the totals have changed. So I just look at that, I think, well, the discretion between yes and no is still kind of, the line's kind of where it is again, but the totals are changing. So maybe we have fewer cases going through the
Well, and
courts.
that would be more my question. I mean,
Right.
in other words, is there less crime? Are we dealing with less cases? And I'm not
Right.
asking you. That's a kind of a
Right.
pontificating question. But is there less crime? Are we dealing with less felonies? That would just be a very good question to know the answer to. In other words, is crime going down? Are we granting more shock probation, less?
Right.
What the trend line is on those?
And that's data that we have as far as totals. If you can see what the courts view, what we're capturing as far as total number of charges and disposition, we certainly have that information, whether that means more or less crime, but we can show you what's happening within our system that compare totals to, these are the total number of felonies, the total disposition, and then see how within that larger unit, how much of these were motions for shock probation, how many were granted, how many were denied, so you can take it from its highest level down to those cases to maybe get a sense of what the trends might be. I mean,
That would be good to see. Do you mind sharing that with our committee?
Sure. We'll
Can you
talk
pull
about
that?
and
Is that
we'll
okay,
pick
Mr.
up-
Chairman, to
Well,
ask for that?
Sure.
Yeah, that's
Clarify the parameters for it, so,
Yes.
yeah.
Okay.
Yes, sir.
okay. Senator Nunn.
Thank you, Mr. Chairman. Thank you all for being here today. I really like the data sets that Representative Blanton asked for, and fixing to see how sophisticated the query is on your database. When we talk about recidivism, is there any way for you to then distill it down further to see someone who was granted shock probation for a nonviolent crime, but then their follow-up or their second crime is a violent crime? Could we see the data that way?
I know
believe so.
we would have data. If we could make the connection, as we mentioned before,
If we identify
I think the only concern that we might have is that if a charge is brought later, like on a violent crime, you could have it charged in 2024, but you actually committed the offense several years before.
Sure.
So I think that from a court's perspective, again, and this kind of goes back to, we need probably to tie in with DOCs, and maybe that could kind of assist, but you kind of have to be careful because we're tracking on charges in a case, right?
Sure.
So our data points reflect the court record, and our court record reflects when somebody's charged. We don't dive into those like offense details, like when the offense was committed. So I think that there would be some asterisks, some little comments,
An explanatory
caveats.
note would be appropriate.
Yeah,
Yes.
yeah.
Absolutely.
So we could, but you just kind of, with those caveats, what you could draw from that would have to be kind of conditioned on, well, this could have actually been an offense that occurred before and just didn't get charged till later. So
That's completely fair. Thank you.
Okay, and along those lines, you've indicated to staff, and what I'm hearing here is you got to have a full picture of probation. What would you need to have a full picture of the probation program? It's going to benefit your staff.
So I can't speak for corrections and what their data looks like, but we are associated with a case number and a specific defendant and charges, and I think the service of the sentence and what the length of that is. Corrections is responsible for calculating the sentence and their custody status. So it would be a matter of getting our data to match up with corrections like custody and defendant data. Daniel, if you want to speak to what touch points or how that connects would work together.
I believe your summary was pretty good. The two independent systems are designed for entry, record, and retrieval for their own business process. Without that intention of being designed to interoperate that way, And so the fundamental unit of analysis in our system is the case, and the fundamental unit of analysis in Department of Corrections, I'm sure they have a good word for it. I'm going to say custody because I don't know the term. And those aren't quite the same thing. There can be more than one case prior to someone's incarceration, for instance. And I've worked with this data a couple of times in the past, and it always takes a lot of legwork to get those to be apples to apples comparisons. So
Right.
I think
My understanding is in the past, you've worked with the Department of Corrections and KY Stats to combine the data. How long did that take, and what did it require?
there were a couple of efforts proposed, and this was related to juvenile data, if you're thinking of the same one that I'm thinking of. And they were able to identify a rate of matching that they were concerned may or may not be accurate, and we did not pursue the matter further because of other priorities. So that was 2023 when those conversations were happening, and the partnership still exists and could be brought back to life. And it's a matter of picking our most important priorities.
All right, Representative Smith.
Thank you, Mr. Chairman. Since they've given you some homework to do, I'd like to see, as was discussed earlier, maybe a breakdown in the circuits on these, on the shock probation, if it's possible. I'm sure it's in the data, what circuits they come from,
Yes,
so we
sir.
can kind of see a map on maybe who's using it more, who's not using it at all, that type of thing, because I think shock probation is a great tool for a judge, and I look at it as a way of serving maybe justice even further after they have a review and they have a chance. Was it 120 days? 30 to 120?
It's 30 to 160, so 1 month to 6 months.
Yeah, so, and most time they're familiar with, the judge is familiar with the case, and he's familiar with attorneys. But the tool, I think, is a good tool. But I'd like to see how that affects the whole state and who's utilizing that. Is it possible, too, to have an idea on incarceration, since we're going to be looking at the data on, since you're on corrections, the facilities that we have, the percentages that we're, the numbers that are in there up to capacity or non-capacity, those type of things, and then also include the private, the private prisons that we contract with. Is that possible?
I think it would get back to the data matching that we would need to do, the data sharing or information sharing, whatever we call it, with corrections.
Yeah,
That's
because
correct.
a lot of
Source information.
A lot of times we're asked to fund these things, mostly the private, and it'd be nice to have the information on why we're shifting from our state to privates, and again in regions. If you could show that, I'd appreciate it.
Sure, we'll have
Thank you,
those
Mr. Chairman.
conversations. We'll include those in our conversations with corrections.
Representative Burke.
Thank you, Mr. Chair, and thank you all for this presentation. I'd like to just follow up on the request from Representative Smith, which I think is a good one. If when you present the data to us, broken down by circuits, if it's possible, would you please give us both the quantity of convictions and then the utilization so we can ascertain the percentages? Because obviously Jefferson and Fayette would, dwarf other circuits just based on the quantity. So I'm interested in the percentages as well. Thank you.
Okay, I'm not seeing any other questions. I appreciate you appearing before the committee here. And with that, I think we're going to move on to the Department of Corrections, please.
Thank you.
Got Allison Brown, the Assistant General Counsel. Ma'am, if you could state your name, your position, please.
It's Allison Brown, Assistant General Counsel for the Department of Corrections.
Okay, and you're free to go on.
Okay. Well, thank you, Representative Sharp and members of this committee. Thank you for the opportunity to speak with you today about what happens after an individual is granted shock probation and comes under the supervision of Kentucky Probation and Parole. So as AOC indicated, shock probation is a judicial tool that is authorized by KRS 439-265 that allows an individual to be released early by the court after serving a short period in custody. The intent is to shock the person with the experience of incarceration and then return them to the community under supervision. The court is solely responsible for determining whether to grant shock probation, and if it is granted, the Division of Probation and Parole then takes over and oversees that supervision in the community. So once shock probation is ordered, the first thing that has to happen is the individual who has received shock probation is assigned to a probation and parole officer in the community where they are going to reside. The offender is supervised the same way as we supervise anybody on probation. So probation, shock probation, it's treated the same as far as the supervision aspect is concerned. One of the first things that the officer has to do is they have to set what we call the conditions of supervision and communicate those to the offender so they know what is expected of them while they are on supervision. The conditions of probation for individuals on shock probation mirror those of traditional probation. There's two types of conditions of supervision that we utilize. We call them the general conditions, and then we have special conditions. Now, general conditions are typically the same for all offenders. We actually have those listed on the Department of Corrections website. They include conditions like obeying all laws, regular reporting to a probation and parole officer, not using or possessing alcohol, narcotics, or controlled substances, compliance with drug and alcohol testing, and maintaining employment or pursuing education. All right, so those are the general conditions. In addition to the general conditions, either the judge or the probation officer may also impose what we call special conditions of supervision. Now, special conditions are unique to each individual offender, and they're based on things like the crime the person has committed or the results of their risk and needs assessment. So special conditions could mandate things like participating in a mental health assessment, following any treatment recommendations, participating in substance abuse treatment, anger management classes, parenting classes, paying restitution. So our officers within the Division of Probation and Parole, they have both an enforcement role and a rehabilitative role, all right? On the enforcement side, they have to monitor compliance with the conditions of supervision, and they have to take action if a violation occurs. On the rehabilitative side, they are also responsible for connecting that offender with community resources, treatment programs, and employment opportunities to reduce the likelihood of reoffending. Right? Now, if somebody does violate a term of their supervision, then the probation and parole officer responds according to, we have a violation matrix that is set out in our corrections policy and procedure. And so that matrix determines basically the type of response that the officer uses to address that violation. So if it is a minor violation, then they can use what's called graduated sanctions, which was also a statute that the legislature passed. Graduated sanctions can include things like, increased reporting. They have to report more frequently to their parole officer. We may refer them to treatment or even issue them, certain number of hours of community service could be a graduated sanction. Now, if the violation is a more serious violation or it's a repeated violation, then the officers will submit a violation report to the court, and at that point, the judge has the responsibility to determine whether that individual should be revoked and returned to custody. So in summary, once somebody is granted shock probation, probation and parole assumes the responsibility at that point of ensuring that individual is supervised according to the court's order. Our officers provide both accountability and support. They work to reduce recidivism and improve outcomes for both the individual and the community. So I want to thank you for your time, and I'm happy to answer any questions that you all may have.
Well, one of the questions I got is I'm looking at this piece of paper. I guess it came from you. It says Department of Corrections Probation Population, and in there under the supervision type, it has ISC. What does ISC stand for?
That is Interstate Compact, and so
Okay.
that is the law that allows somebody. It could be somebody who is convicted in another state and wants to come to Kentucky, and Kentucky probation and parole will take over their supervision, or somebody who is on probation, has been convicted in Kentucky, can transfer out to another state and have their supervision done in that state.
Okay, and I understand. I got the same question to you as I had for AOC. Is you've indicated to the committee staff that you don't have a full picture of the probation, and what would it take for you to get that?
Can you explain what you mean by a full picture?
Well, I guess a full understanding of what's going on. It seems like you've got a piece and AOC's got a piece, and together, it's not being put together.
I mean, we have the information about what happens after they are granted shock probation. Now, what happens before that between them and the court, we have no involvement in. We're not, we don't provide recommendations to the court about whether somebody should be granted shock probation. All we know is they were convicted, they were sentenced to custody, and then we receive a separate order that says, okay, we're now going to grant this person shock probation. So we release them from custody and get them assigned to a probation and parole officer.
Okay. Does DOC have data on a typical length of probation, and does it tend to vary with the different offenses?
I believe by statute it can be up to 5 years, but that's completely up to the judge to set how long that supervision period is going to run.
Okay, and do you have typical requirements of probation that you use?
We have our general conditions of supervision that I talked about that we have on our website. But then beyond that, it's very individualized based on the particular offender.
Okay, so for the offender, you have specifics you can go into. Okay. All right, any questions? Okay, I believe that's it. And if there are no further questions, all right, I'll entertain a motion to adjourn. I need a second. All right, we are adjourned.